Drummond.
Thank you very much, Madam Deputy Speaker. And can I also thank the Honourable Member for Dundee West for bringing this important debate forward. And I need to declare an interest that I visited Israel and Palestine in 2016 with some other MPs, and it's recorded in my register of interest. I want to concentrate on one aspect that's not often raised in public, and that is the detention and imprisonment of Palestinian adults and children from the occupied Palestinian territories, a central part of Israel's military occupation. In 2016, we visited the Israeli military court at Offa and saw how it works in person. Only Palestinians are tried in military courts. Settlers in the OPTs are tried in Israeli civil and criminal courts. The UN Special Rapporteur wrote as part of his report in October 2018 about how the extension of Israeli laws to the West Bank since 1967 has created a discriminatory legal regime. If an Israeli settler child and a Palestinian child threw a stone in the same area, the former almost certainly would not land up in a court and would be protected by Israel's legal system. However, a Palestinian child will face a military court. Israel's military court at Offa has, by its own figures, a 99.74% conviction rate. Why? Because lawyers advise Palestinians to plead guilty in order to get out earlier. And I will leave it up to my honourable friends to weigh whether this is actually justice. International law is very clear on the legal authority to impose military law and establish military courts to try civilians. The key provisions are found in the Hague Regulations and the 4th Geneva Convention. Articles 64 and 65 of the 4th Geneva Convention state that local laws may be suspended or revoked where they constitute a threat to its security, and replaced with military law enforced in properly constituted non-military courts. This is what the Israeli military authorities use as a jurisdictional basis for establishing military courts in the West Bank. However, international law also stipulates that occupation should be on a temporary basis, including prosecuting civilians under military law. Israel's military court policy has been in existence for, as we heard earlier, for 56 years, hardly a temporary solution. The PLO's Ministry for Detainees Affairs estimates that over 850,000 Palestinians have been detained since 1967. The wide-ranging military regulations governing every aspect of Palestinian life and the military orders provide for a wide range of offences divided into 5 categories, some credible, some not. So, for instance, hostile terrorist activity. I think that's acceptable. Disturbance of public order, acceptable. Classic criminal offences, illegal presence in Israel and traffic offences committed in the OPT. The question here is, do the last 3 really need to be tried in a military court, and are the sentences proportionate? For example, under Military Order 1651 from 2009, throwing stones is considered a security offence. The punishment is up to 20 years of imprisonment. There is detention without trial. Palestinians may be held without charge for a period of up to 6 months using administrative detention order issued by an Israeli military commander. And we met one military commander recently who was with breaking the silence. I think he was 21 when he made these sort of orders. So very young to have such an influential impact on somebody. This can be renewed without charge or trial. And as of October 2022, there were 798 Palestinian prisoners being held under an administrative detention order, including 8 members of the Palestinian Legislative Council. The majority of these prisoners have served in excess of 6 months behind bars. So it's important that I give the House some detail about what happens too. Detainees are handcuffed and blindfolded, including children. Some of them are kept in total isolation, as we've heard, and there are widespread allegations that they're threatened during interrogation. 70% of child detainees and 80% of adults have been unlawfully transferred to prisons in Israel in violation of the 4th Geneva Convention and the Roman Statute of the International Criminal Court. It's not that old. I now want to concentrate on what happens to children in particular. Israel is the only country in the world that systematically prosecutes children in military courts. 95,000 children have been detained since 1967 in the West Bank. Stone throwing is the most common charge, and it is often unclear who's actually thrown the stone. Now, stone throwing is not acceptable, But no child should be arrested in the middle of the night, roughed up as it happens, taken by the army without a parent or responsible adult, and interrogated without a lawyer present. Worst of all, families are not informed where their children are taken, even though Military Order 1676 requires that a police officer informs the child's parents of its detention. In most cases, Palestinian children are taken to detention centres in larger Israeli settlements across the West Bank, and parents take the time to find out where their child is. In 99% of cases, children are denied access to their parents or a lawyer and are unaware of their right to remain silent. During COVID, families were unable to visit their children. Confessions are often signed in Hebrew, which few of the Palestinian children understand, and 90% plead guilty, regardless of whether they actually committed the offence. Children should be offered the same protections as would be granted in a civil court. In all of this, Israel is violating the numerous provisions of the UN Convention on the Rights of the Child, which Israel actually ratified in 1991. The criminal age of responsibility is 12. In 2011, military orders raised the age of majority from 16 to 18. This means that under 18s must be tried in juvenile courts, bringing it in line with international standards. However, this does not apply to sentencing, and 16 and 17-year-olds are still sentenced as adults. Now, all of this is common knowledge if anyone cares to look. It was confirmed in the legal report that the Foreign Office funded in 2012, which found that Israel was in breach of 8 of its international legal obligations under the UN Commission of the Rights of the Child and the 4th Geneva Convention. But 11 years on, sadly, little has changed. There are 151 Palestinian children in military detention as of the 31st of March 2023, an 11% increase compared with 2022. And I would urge the Minister to revisit the report and push for change. Following UNICEF's Children in Israeli Military Detention, which found that there was ill treatment of children in the military detention system, Israel reduced the maximum amount a child can be detained before appearing in front of a judge from 4 days to 24 hours for children from age 12 to 13, and from 4 to 2 days for children aged between 14 and 15, but no change for 16 to 17-year-olds, which remains at 96 hours. Settlers' children enjoy much shorter periods of detention before seeing a judge and allowed access to parents and lawyers. The resentment that each of those 95,000 children must grow up with towards the Israeli Defence Force must be huge. And to say it is counterproductive must be one of the biggest understatements I've made in this House. As Right Honourable Sir Stephen Sedley states in his foreword to Save the Children's report, Defenceless, whatever one's view of the ongoing conflict and its causes, there is no excuse for the systematic infliction of psychological harm on a generation of young Palestinians. Sadly, in most Palestinian children's only experience of Israelis is framed by the experiences and violence from Israeli soldiers and illegal Israeli settlers. I would urge Israel to ensure that through the entire arrest, interrogation and court process, Palestinian children are provided the same safeguards as Israeli children in civil courts. The UK government and its partners have direct responsibility to ensure this happens as high contracting parties to the 4th Geneva Convention. I would urge the FCDO to deal with this as a matter of urgency.